Will the Senate please come to order? Please join me in a moment of silence today in lieu of a devotional. Thank you. Are there any announcements this morning? We have a House resolution, JRH2, Joint House Resolution 2, apologizing and expressing sorrow and regret to all individual Vermonters and their families and descendants who were harmed as a result of state-sanctioned eugenics policies and practices. It was adopted in the House on April 1st, 2021. Please listen to the resolution by title.
JRH 2. Joint resolution sincerely apologizing and expressing sorrow and regret to all individual Vermonters and their families and descendants who were harmed as a result of state-sanctioned eugenics policies and practices.
You've heard a reading of the resolution. Pursuant to the rules, the resolution is treated like a bill and referred to the Committee on Government Operations. This brings us to the orders of the day. We have on the calendar for action S100, a committee bill referring to universal school breakfast and lunch for all public school students and to creating incentives for schools to purchase locally produced foods, which was introduced on February 26th, 2021. The bill was referred to the Committee on Education, which reports it has considered the bill and recommends that the bill ought to pass. The bill was then referred to the Committee on Appropriations, which reports it has considered the bill and recommends that the bill be amended as appears on page 972 of today's calendar. The senator from Essex Orleans is recognized.
Yes, thank you, Madam President. I'd like to move that the Senate Ag and the Senate be relieved of S100 and it be referred back to Education for further review and amendments. The reason that I'm making this motion is that there is a new proposal of funding and the way we deal with this bill. And the Senate Ed has that proposal, and I'd like to move the bill there so that it could be vented and put into the S100.
Thank you, Senator. The chair will briefly confer with the secretary. Senator, if I may, our understanding was that the move today or the motion would be for the bill to lie. You've moved for the bill to be committed to the Committee on Education. I just want to confirm your motion.
Well, I would move it to lie, but I'm wondering, could the Committee on Education continue to work on the bill and then offer their amendment to the full Senate in future days?
We could do a substitution report.
It's my understanding that a substitution report could happen.
Okay, I'd change that then to move it to lie.
The senator from Essex Orleans has moved that S100 be ordered to lie. Are you ready for the question? So kindly unmute. All those in favor, please signify by saying aye.
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 Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've ordered S100 to lie. We have on the calendar for action H20, read for the first time on February 11th. 2021. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as set forth on pages 977 to 979 of today's calendar, and that when so amended, the bill ought to pass. Please listen to the second reading of H20.
H20, an act relating to pretrial risk assessments and pretrial services.
The senator from Bennington, Senator Sears, is recognized for the report of the Committee on Judiciary.
Madam President, thank you very much. I was planning to give a short report on H20, but I was struck last night when I read a message from the Vermont Police Coalition, not the Vermont Police Association, not the Chiefs Association, but this message, that referring to H20, this is just another process to lessen the prison population by making violations of conditions of release, probation, parole, or furlough, not being offenses for which a person would normally go back to jail. Criminal sympathizer, Senator Dick Sears, has been pushing this agenda for some time. If only he and the legislature cared so much about the victims. Vermont residents need to contact their lawmakers and tell them not to endorse this measure. Vote no to keep us safe. Madam President, when I read that, I thought maybe I should just give a little bit of a history about H20 and our efforts to keep Vermonters safe. And I'll stack my record in support of victims with any other member of the Senate, past, present, and future. But Madam President, our efforts at justice reinvestment go back to the Douglas days when we did Justice Reinvestment 1, when we were the fastest growing prison population in the nation. And our projections for increases in prison population were up to 2,800 people. We're now down well below that, well below actually 1,500 people incarcerated. Our numbers out of state at that time was 750 inmates. Today, it's under 200. And we've done all that while remaining one of the safest states in the nation. And the way we've done that is to make sure that those that we lock up are the people that need to be locked up. What we found during the effort of Justice Reinvestment 2, which is now ongoing, and which H20 is a part of, is that in Vermont, roughly 20% of the new admissions to prison are people on violation of probation. Roughly 79%, hard to be rough at 79%, but 79% of the admissions are people who failed at probation, furlough, or parole. The majority of them being on furlough. Last year and this year, we have passed legislation to dealing with probation and furlough to further keep Vermonters safe. If someone does not commit a new crime while they're on probation, that means that there is less criminal activity. It also means that the person is being productive. H20, has to do with, relates to risk assessment and pretrial services. It is part of the overall justice reinvestment effort, because if you think about, if somebody was going in because they suffered some heart problem and went to the emergency room, but the emergency room immediately sentenced them to a full heart transplant operation without doing any assessment of the needs of the person? Would they do other measures without assessing it? Risk assessment is a similar tool. It tries to look at what is the risk of the person based upon prior information. H20 got its start in the House as an act relating to risk assessment and pretrial services. Under current law, when a person is arrested for suspicion of committing a crime, that person may participate in a risk assessment or a new need screening before trial. Participation is voluntary, so the defendant may choose whether or not to participate. The objective of pretrial risk assessment is to provide information to the court for the purpose of determining whether a person represents a risk of reoffense, so the court can make an appropriate order concerning bail and conditions of pretrial release. The objective of the pretrial needs screening is to obtain a preliminary indication of whether a person has a substantial substance abuse or mental health issue that would warrant a subsequent court order for a more detailed clinical assessment. H20 has 3 elements. The first, it eliminates the use of risk assessments almost completely with one exception. Second, it makes needs screening and other pretrial services available to all offenders who are charged as juveniles, and regardless of age. And third, it creates a pilot project for the Department of Corrections to provide the court with a report before sentencing defendants to probation for felonies. Madam President, one of the things that your Committee on Judiciary looked at during the process of risk assessment was whether or not risk assessments are biased based upon race or ethnicity and other factors of the defendant. And it's important that we only use instruments that have been appropriately validated by race and ethnicity. It's important to never make decisions based solely on a score-based classification of risk. The job is to prevent, not predict. Think beyond and consider the relevance of different risk factors to different racial groups, and to be sure to track outcomes. So, yes, there is some evidence of some risk assessments being biased. However, in this small group, it's important to note that risk assessment pre-trial are very difficult to and so we're not requiring them under this bill, H20, for the pre-trial. There are 4 places where risk assessment is used. It's pre-trial, pre-sentence, post-conviction, post-conviction, post-sentence, post-release, should someone have been incarcerated. Recommendations for the pilot project are at the pre-sentence investigation stage, not at the pre-trial stage. There are roughly 80 people who are held in our prisons awaiting trial, on bail conditions, where they can't make that bail. And this would allow, the first part of H20 changes the requirement for a risk assessment being offered for anyone who's been arrested and is unable to post bail for 24 hours. H20 changes this in 2 ways. First, H20 eliminates the use of risk assessments completely for determining whether a person presents a risk of reoffense. Only one use of risk assessments would be permitted that a judge can request that a pretrial services under the, excuse me, Madam President, I've lost my place. Caseworker administrative risk assessment with respect to the person's risk of non-appearance or flight. If the person's been detained for lack of bail for more than 24 hours, the judge may request rather than shall request an assessment, which is the second change to risk assessments made by H20. This reduction in risk assessment is being done in large part because it's been discovered that pretrial services staff are prohibited by federal law from assessing the necessary criminal history records, which means the assessments cannot be fully completed. The second thing that H20 does is, since the majority of risk assessment uses are eliminated, In most instances, there's no longer any need for the statute to continue using the phrase risk assessment. The bill therefore removes mention of risk assessment from pretrial services statute entirely, with the one exception described above. These changes begin in subsection A, which deals only with risk assessments and is therefore struck entirely. References to risk assessment are also struck in subdivisions B4 and B5 as they're no longer relevant or necessary. The second element of H20 appears in subdivision B6. Several years ago, the legislature expanded juvenile jurisdiction to permit some persons 18 or 19 years of age to be charged as juveniles in the family division rather than as adults in the criminal division. This language in H20 permits that group of persons, those subject to delinquency petitions who are 18 or 19, to assess pretrial services in the same manner as those under the age of 18. This ensures that everyone eligible to use pretrial services prior to the expansion of juvenile jurisdiction retains that eligibility. The third element of H20 is the creation of a pilot project requiring the Department of Corrections to provide the court with a report prior to the sentencing of any defendant to a term of probation for a felony. The report is designed to assist the courts in setting probation conditions and must include the defendant's risk and needs assessment results, mental health and substance use disorder screening results, and criminal history. The hope is that this type of risk assessment will help us to lower the number of violations of people from probation, provide successful reintegration into the community, and keep our community safe. The Department of Corrections, the Court Administrator, the Department of State's Attorneys and Sheriffs, the Office of Attorney General, and the Office of Defender General will jointly select 1 or 2 units in the criminal division to participate in the pilot project. The pilot department will report the results of the pilot project to the Joint Legislative Justice Oversight Committee by December 1st, 2022, and the report will recommend whether the pilot project should be made permanent throughout the state or not. Lastly, the bill takes effect on passage. Madam President, your Committee on Judiciary heard from a wide range of witnesses, including Willa Farrell, Director of Court Diversion and Pretrial Services, Eric Fitzpatrick, Legislative Counsel, Brian Grissom, Chief Superior Judge, David Sherb, the Attorney General's Office, and Matt Valerio, the Defender General. All of them support H20, and the Senate Judiciary Committee voted 5-0-0 to support the bill, and we urge the Senate to also support H20. Thank you.
Thank you, Senator. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? The senator from Addison is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill?
You may.
Thank you, Madam President. I'm just wanting clarification, just to understand. I believe you reported that the pretrial risk assessment process has been changed or eliminated, perhaps at the federal level, and that was part of the impetus for this change. Is that correct?
Thank you. No, Madam President, part of the impetus for the change was that the Pretrial Services Division of the Attorney General's Office is not entitled to the background information, the criminal history record of offenders. However, the Department of Corrections is. And so because it's pre-trial, to try to make decisions without knowing the criminal history background would be difficult. And so it's been changed to a may.
I see. Okay. Thank you for that clarification. Thank you, Madam President.
The senator from Franklin is recognized.
Thank you, Madam President. May I interrogate the report of the bill?
You may.
One of the most frequent complaints that I hear about the criminal justice system is that someone is charged with a serious offense that the public in general knows has been a multiple offender for other felonies or other crimes of violence, and they are released on probation or out on bail. And that then we read in the newspaper that that individual is charged again with some violation of probation or violation of conditions of release, and then goes back and is given further conditions of release and is released again and again and again. Does this bill offer any solution to that problem? And if not, is there a solution to that problem?
Well, that's a multifaceted question, and I'd like to try to, if I don't answer it all, please ask again. But this bill does not solve that problem necessarily in terms of those that are charged with something and then released on their own recognizance or released with conditions. Because the only way that somebody can be held on bail is when they're a danger to the public. That'd be significant, like a murder case, or if they're a risk of flight. And that's under our Constitution. And so a lot of these cases where judges have made decisions that the public doesn't particularly appreciate are made because that's what the Constitution requires. In terms of the probation, we're hopeful that this violations and that this pilot project would be successful in making sure that we're getting the right tools to the probationer so that they're less likely to violate probation, less likely to, because their needs would be being met in terms of whether it be substance abuse treatment, mental health treatment, whatever that need might be. And that's what the need screening would hopefully show them. I hope that answers your question, Madam President.
The senator from Windsor is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill, please?
You may.
Madam President, when in the answer to the previous question, needs being met that are identified from repeat offenders on probation, does this bill also then have an appropriation for more mental health and drug counseling? Because as we know, I mean, we wish we had enough places for everyone who actually needs help, and then it requires them to actually get the help rather than they're leaving once they're sent there because they can voluntarily leave. I mean, does this bill have an appropriation that expands the services that might be required?
In terms of the pilot project, the answer is no. It doesn't. The bill doesn't specifically have an appropriation. However, justice reinvestment has some appropriations within it, and that section of the bill with the pilot project is a recommendation of justice reinvestment too. And I believe that our appropriations committee is continuing its work to try to find the funding to help and recognize the needs in the community. The pandemic, of course, has created havoc with a lot of offender counseling, offender needs screening, and most of the domestic violence programs for abusers rely on a group meeting in the community. And obviously, it's been difficult to hold groups during a pandemic. And a lot of the substance abuse treatment requires groups, and that's been also difficult. And so that just is to it. Although we're happy that at least $900,000 of justice reinvestment money is in the governor's budget. We hope to make it more in Senate appropriation, particularly on the mental health side.
Thank you. Thank you.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you propose to the House to amend the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read for the third time? The senator from Windham is recognized.
Thank you, Madam President. I just want to take this moment because I think the legislature often works year after year on projects that the public may never know about. And this particular project, continuing the work of Justice Reinvestment, dates all the way back to 2007, 14 years ago, when Vermont was one of the very first states to take on the work of Justice Reinvestment. And I was really curious about the email that the senator from Bennington, the chair of Judiciary, received, because it's clear that there's a fundamental misunderstanding about the work of Justice Reinvestment. And so I want to just remind senators and tell senators who are new to the work, and also for the public that's listening, at its core, Justice Reinvestment is about public safety. And there are four basic prongs of the stool that hold it up. And the first is to reduce recidivism so that people don't reoffend. The second is to repair harm to victims, something that I know the entire Judiciary Committee has been focused on. Preventing crime is also one of the four pillars. And the last one, building trust in communities that have been impacted by violence, crime, and incarceration. So I just want to reassure anyone who might be listening, at its very heart, the work of Justice Reinvestment is about public safety. Thank you, Madam President.
Thank you, Senator. The question is, shall the bill be read the third time, for the third time? Are you ready for the question? So kindly unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've ordered third reading of H20. This concludes the orders of the day. The senator from Windham is recognized.
Thank you, Madam President. Pending announcements, I move that the Senate stand in adjournment until Tuesday, April 6th at 9:30.
The senator from Windham has moved that, subject to any announcements, the Senate do adjourn until Tuesday, April 6th at 9:30. Are there any announcements? The senator from Caledonia, Senator Benning, is recognized.
Thank you, Madam President. Senate institutions will meet at 1 o'clock.
Thank you. The senator from Washington is recognized.
Thank you, Madam President. Senate Finance will meet at 1:30.
Thank you, Senator. The senator from Windham is recognized.
Thank you, Madam President. Senate Government Operations will meet at 1 o'clock.
Thank you. The senator from Bennington is recognized.
Thank you, Madam President. Senate Education will meet at 1:15.
Thank you. Are there any additional announcements? Seeing none, hearing none, the senator from Windham has moved that, subject to any announcements, the Senate do adjourn until April 6th at 9:30. Are you ready for the question? All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and the Senate stands adjourned until Tuesday, April 6th at 9:30.